I am attorney Maricris Bathan-Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, we shall aim to simplify the law. We shall explain concepts and principles of law in under 10 minutes. In this video, we shall discuss the difference between ordinary delay and legal delay. These are two important concepts in civil law that we must know and understand, whether we are lawyers or non-lawyers or non-law students. In relation to these two concepts, we have a principle in law which states, if there is no demand, then there is no delay. Now, in that concept or in that statement, when we say delay, what type of delay are we referring to? Since we said there are two types of delay. You have your ordinary delay and you have your legal delay. What then is ordinary delay? Ordinary delay is non-performance of an obligation after the lapse of the agreed time. While in legal delay, there is also still the lapse of the agreed time and still there is no performance of the obligation. However, unlike your ordinary delay, in legal delay, there was already a demand that was made. Now, why is it important to determine whether this is merely ordinary delay or if this is legal delay? The reason for that is your civil law will tell you that if you incur delay, if there is delay, then you will be made liable for damages. What kind of delay will let you be liable for damages? The answer is legal delay. To further understand the difference between the two, let me give you an example. For example, Maria and Marjorie agreed that Marjorie will deliver a particular car to Maria on July 1, 2021. Supposing today is already September 20, 2021, and still there was no delivery of the car yet by Marjorie to Maria, and it's already September 20, 2021. Clearly, there is delay. But the question now is this the kind of delay that will entitle Maria to receive damages from Marjorie? Will it make Marjorie liable for damages? The answer is, it depends. It depends on what? It depends on whether Maria has already made a demand upon Marjorie to deliver that particular car to her. So, if Maria has already made a demand upon Marjorie to deliver that particular car to her on or after July 20, 2021, which was the agreed period, and still Marjorie did not deliver, then Marjorie is liable for damages because there is already a demand that was made by Maria upon Marjorie. In other words, if Maria did not make a demand upon Marjorie to deliver that particular car, even after the lapse of July 20, 2021, there was no demand made yet by Maria upon Marjorie. If today is September 2020, 2021, and still there was no demand that was made by Maria upon Marjorie, then Marjorie still cannot be made liable for damages because there is no legal delay yet. Again, if there is no demand, then there is no legal delay. If there is no legal delay, then you will not be made liable for damages. Apart from knowing the difference on the effect of liability for damages on account of delay, be it legal or ordinary delay, another important difference on legal delay and ordinary delay is liability for damages on account for loss due to fortuitous events. In ordinary delay, there could have been loss of a particular thing, which is the object of the contract or of the obligation, before a demand was made. Vis-a-vis in legal delay, where there is already a demand that was made, and then there is loss of that particular thing that is the object of the contract or of the obligation after the demand was made, but still the loss was due to a fortuitous event. What are the effects under these two different circumstances? If there was loss of that particular thing, which is the object of the contract, and the loss was due to a fortuitous event before a demand was made, then the obligor is not liable anymore. There is no more liability to even deliver that particular thing that was lost due to a fortuitous event. On the other hand, if there was already legal delay because a demand was already made, and then that particular thing that was promised to be delivered was lost even due to a fortuitous event, but the loss occurred after the demand was made, is the obligor still liable? Yes, the obligor is still liable. And it may now be in the form of damages. Again, to better understand the concepts, we have to illustrate and give an example. So for example, there was a promise to deliver a particular or a specific car on July 30, 2021. There was no demand made yet. From July 30, 2021, even up to August 10, 2021, no demand was made. And then the car gets totally wrecked due to a typhoon on August 10, 2021. Is the obligor or the debtor, the one who promised to deliver that particular car, is he still liable to deliver, or is he liable in the form of damages? The answer is no, he is not. Why? Because this is an ordinary delay, because there was no demand yet. And because of such, the loss due to the fortuitous event will release him from liability. Now, how about if there was also still a promise to deliver a particular or a specific car on July 30, 2021? No demand yet on that date, but there was a demand on August 5, 2021. But despite the demand, the obligor or the debtor did not deliver that particular car that he promised. And then comes a typhoon. And a typhoon totally wrecks the car. Is a typhoon a fortuitous event? Yes, it is a fortuitous event. If today is August 12, 2021, and there is no delivery yet because it can no longer be delivered because the car was already wrecked by the typhoon, is the obligor or the debtor still liable when in fact the loss was caused by a fortuitous event? The answer this time is yes, he is liable. Why is he liable? Because there is already legal delay. So even if the loss was due to a fortuitous event, since the loss came after the demand that was made, he is still liable. And now he is liable in the form of damages because clearly that particular car was already lost due to a fortuitous event. That ends our short discussion on the difference between ordinary delay, and legal delay. If you have learned anything from this video, please feel free to click like and subscribe. If there are any topics or principles of law which you want me to discuss, kindly put in the comments below. See you next time.